At Hackard Law, we do California estate trust and elder financial abuse litigation. Our practice experience includes circumstances where it seems that estate planning lawyers haven't really done their job. The few examples below are collected from real-world experience and changed to protect the privacy of the parties involved. The first example. Angus Flinch, a lawyer with 17 years' experience, has a limited estate planning practice in the East Bay. Jose Carlito, the son of Juanita Carlito, calls Angus in late 2017 to set up an estate planning appointment for his mother. Juanita, 78 years old, has a will in place that distributes her assets equally to her two children at death. Juanita, a Spanish speaker, has a third-grade education and a very, very limited understanding of English. Jose drives Juanita to the first appointment with Angus. Juanita barely says a word. Jose explains that Juanita wants to leave everything to him, Jose, and she also wants to disinherit his sister Inez. Angus prepares a trust according to the terms that Jose describes. Juanita returns a week later. Angus does not speak Spanish. Susie, assistant to Angus and able to speak just a little Spanish, explains some basic terms of the trust to Juanita. Juanita cannot read the trust. No one reads the trust to her. Juanita signs the trust. Juanita dies, and Inez, her disinherited daughter, hires Hackard Law to challenge the trust and her brother Jose's actions. Another one. Charlie Gambino, a Southern California lawyer, meets with Sadie Sark, an 87-year-old widow in poor health, at his office regarding her estate plan. Sadie's accompanied by her nephew, Mortimer, at the first meeting. Sadie indicates that she wants to change her trust, disinherit her three children, and name Mortimer as the trustee and sole beneficiary of her trust. Sadie's prior and long-held estate plan provides for an equal division of her trust assets to her three children at her death. Sadie also wants to give Mortimer her power of attorney and add him as a joint tenant on a condo that she owns in Palm Springs. Charlie Gambino directs all of his follow-up questions from the first meeting, including emails and phone calls, to Mortimer, who's not his client. His client is Sadie. This follows Mortimer's instructions. Mortimer emails Charlie a list of all of Sadie's assets and a list of joint accounts that Sadie holds with him. Charlie does not speak with Sadie during the 2 months between the initial meeting and the execution of the new trust. Sadie comes to Charlie's office to sign the trust. Mortimer, of course, accompanies Sadie to Charlie's office. Sadie dies. Winston, one of Sadie's three children, hires Hackard Law to challenge Sadie's trust and Mortimer's actions related to the trust. Charlie, in a later deposition, says that he didn't see any undue influence from Mortimer. He also says that he didn't really ask Sadie about why she wanted to disinherit her three children. So we'll have another one here. Soccer Banzetti, a South Bay lawyer, focuses his practice in dealing with a financial advisor, an advisor named Sam Shaky, who sends him business. Sam now is not a licensed attorney, and he solicits clients by phone calls and door-to-door sales. Sam promises a complete estate plan for $3,200. And then Sam usually receives the entire $3,200 up front and then pays Soccer $500 for Soccer's work. Soccer and Sam have been doing this for the last 5 years, and they average about 50 estate plans per year. Sam contacts Bifford Jones and sells Bifford an estate plan. Soccer prepares the plan, sends it to Bifford, and Sam goes by Bifford's house, where he notarizes Bifford's signature on the plan. Bifford's estate plan names some strange people as beneficiaries of his trust. A neighbor is named as a trustee. Bifford dies, and his only son, Pierre, disinherited in the trust, engages Hackard Law to challenge the trust. Now, is anything wrong with the way that attorneys Angus, Charlie, and Soccer performed? Well, let's start with the basic legal rule that an attorney has a duty to communicate with the client, according to California Business and Professions Code Section 6068. And this is also part of the duty to render competent representation under the California Rules of Professional Conduct. And it sure looks like these three lawyers had little or no mutual communication with their clients. Lacking such communication, How could they draft an appropriate estate plan? Professor Mary F. Radford's recommendations for lawyers is worthy of consideration by busy lawyers who regularly draft estate plans. Its highlights include lawyers need to have greater education on elder abuse issues. Lawyers should understand that legal instruments that might be used in the exploitation of elders. They need to learn how to deal with clients with diminished capacity. They need to know how to report elder abuse. And they really should seek out trusted contacts in various fields who are experienced in protecting seniors from abuse. Hackard Law represents foreign, out-of-state, and California clients in California trust, estate, probate, and elder financial abuse litigation. We take significant cases where we think that we can make a substantial difference, and there is a wrongdoer who can be made financially accountable for their wrongdoing or breach of duty. We focus our geographic reach to the Superior Courts, Probate and Civil of Los Angeles, Orange, Santa Clara, San Mateo, Alameda, Contra Costa, and Sacramento counties. If you'd like to tell us about your case, your story, then call us at 916-313-3030. We'll be happy to hear from you. Thank you.